Thank you very much. Thank you very much for joining Snijman de Jager and our bit of a chat that we would like to have with you regarding sectional titles and I think the fallacies that we have with regards to certain specific aspects of sectional titles. Now, first and foremost, there is an inherent difference between sectional title and full titles. Sectional titles obviously basically amounts to more units or more dwellings on one stand, whilst you have full titles, which includes the total stand itself with all improvements on it. So if we have a look at sectional titles, it basically entails that you receive transfer of the property, but only the 4.5-inch walls of the relevant unit. You ask yourself, what happens to the outside 4.5-inch walls or the land that surrounds the unit? And the answer to that basically is that it results or amounts to common property. Now, the further question might be is, to who belong the common property? And the answer to that is the body corporate. Now, you might say that, all right, the body corporate consists out of all the registered members. Therefore, indirectly, we own, as registered member, we own the common property. And the answer would be correct. However, it is an undivided share, which share is basically calculated in relation to your participation quota. Now, this participation quota is expressed as a percentage of your interest in the sectional title scheme as a whole. In other words, if my unit would be 100 square meters and the total square meterage of the unit or all units would be 1,000, it would be expressed as a percentage, being 100 on 1,000 times 100 on 1 being 10%. Now, this is significant to have a look at why we have a participation quota. And the reason for that is obviously to determine what rights to vote I have, and secondly, what contributions I have to make in the event of paying levies. Now, the biggest problem that we have in sectional titles is when specific registered owners start adding to their residential units. Many people, and especially in the event of duets, reckon that they either have a parking area or they have a garden area which belongs to them in ownership. And that is unfortunately not true. In 99% of the cases, these specific amenities fall on the common property. And therefore, you might have the exclusive use of that relevant parking area, or you might have the exclusive use of a relevant storeroom or a garage, depending on the character of it. However, it still remains common property, and therefore the common property belongs to the body corporate. And if you add to a relevant building, or you do certain amendments and thus change the footprint of your sectional title unit, you need to get the permission from the body corporate itself. To be totally honest, you need to obtain the land on which this extension is going to take place, because you need to incorporate it in your sectional title unit. Building or adding to a sectional title unit, therefore, amounts to building on common property, and therefore it needs to be included in the relevant unit itself. Now, the question that a lot of people ask is, what are the steps that I have to go through when I do additions to my sectional title unit? First and foremost, you need the consent of the body corporate. So any proposed amendments, such as an addition of a study or an extra bedroom or whatever the case may be, needs to be presented in a resolution type format to the body corporate to say, this is what I need to do or what I want to do in the form of additions. It needs then to be approved by the body corporate. After such approval has been provided, you need to amend the relevant building plans, because there is going to be structural changes, and therefore you need to consult the local authority for purposes of their consent. They need to approve the building plan. Now, a lot of people stop here and think that that is sufficient. They start with a building works based on an approved plan, and that's the end of the story. But the problem is that you have now changed the footprint of the relevant unit. And therefore, you need to change the outlines of the sectional title plan as well, by default of which the extent of your relevant unit will never be adapted. If you do a deeds office search after the repairs, the extent as per the initial extent will remain exactly the same, unless you include or incorporate that relevant addition in your unit. And the way you do that is prescribed in terms of Section 26 of the Sectional Titles Act. So the following step would be is to get a surveyor out, and the surveyor would have to re-survey the sectional title plans. Those specific plans are then lodged with the Surveyor General's office and approved. As soon as they are approved, we are then in a position to proceed via a town and regional planner to obtain a SPLUMA certificate, and that SPLUMA certificate together with the approved sectional title plans are then registered in the deeds office to obviously include and extend your unit. It's only upon that successful registration that you will have an extent that is adapted to obviously reflect the correct size and extent of the unit with the necessary amendments. We can do such a specific application simultaneously with transfer. It is possible, but I always advise estate agents who work and sell sectional title units to be very vigilant with regards to the extent of the unit. If you do a deeds office search with regards to the unit itself and you compare it to the actual extent of what you see when listing the property, there should be either a discrepancy or there should be certain anomalies that you have a look at and can identify in advance. If it seems that the additions or the construction has been done towards the sectional title unit, it's of the utmost importance that that situation would have to be identified immediately, because then in advance you can notify your seller that there has been additions and that the necessary amendment to the sectional title scheme needs to be done either prior to sale of the property or simultaneously. As far as possible, we obviously try and curb the time limits, and we need to bring the transaction within the prescribed time limits. And if we have to do an extension to the section by means of amendments of the sectional title plan and the like, it obviously takes longer, and we try to curb that as far as possible. It is therefore of the utmost importance that you consult your legal practitioner to obviously see what you would like to do and what steps you have to take in the event of additions to your unit and the sectional title scheme as a whole. But you have to work in unison with the body corporate, with the surveyors, with your legal practitioner to get that extension registered in the deeds office. And there are a couple of additional hoops that you have to jump through, which is not necessarily the case if you have a full title unit. In the event of full title, you purely need to lodge a building plan for the additions. Those building plans are then approved, and then you can proceed with the structure. Because remember, the character difference between a sectional title is there. In a sectional title, you deal with the unit itself, and there's common property surrounding it. Whilst as in the event of a full title, you own the whole stand with all the improvements on it, and you merely need to legalize those improvements by means of an approved building plan. Ladies and gentlemen, I thank you very much for your time. I don't know whether you have any questions, and if not, we hope that you found this session insightful. Thank you very much. Have a nice day. Goodbye.